Michelle Ostrowski, Steve Zalewski, I apologize for destroying people's names, Jeffrey Clayton, and Ed Forcione, all representing the New York State Bail Bondsmen Association. One is representing the American Bail Coalition. So again, we could do this as 2.5 minutes each, or some other breakout of 10 minutes for the both of them.
Two of us are going to cede our time to two speakers.
Very good, thank you.
You're welcome.
Good evening. My name is Jeff Clayton. I'm the Executive Director of the American Bail Coalition. Thanks for having me today. Proud graduate of the University of Rochester. Traveled to 35, probably 40 states working on this issue. I am a national expert on it. Recently published a peer-reviewed article on bail reform, the UCLA Criminal Law Review. Worth a read, at least I think so. I'd like to make a couple of points on the bail reform package presented by the administration. First, I think the New York system is different, and you need to recognize that. The affordability of bail is different in New York than elsewhere, largely because dangerousness is not a consideration and has not been a consideration in New York ever. The average felony bail in New York City is $5,000. The average felony bail nationally is $10,000. The average bail in California is $50,000, to give you an idea. The other thing is we don't see the due process issues in New York that we see elsewhere. There's no bail schedules. There's no sitting and rotting waiting to see a judge. And I presented the New York second de novo hearing as a policy idea to many other policymakers around the country as an example of good due process. Second, the proposal that has been submitted will be extremely costly to the state. We've submitted a cost study and other information we encourage you to review, which we're in the process of updating right now. But you could look upwards of a couple $100 million depending on how the estimates turn out, and that's going to primarily hit local governments. Third point I'd like to make is that no major reform of this size has happened in any state that I've worked in without a major study of the system. And every time we go through one of these studies, what we learn is that there's unique issues in each state that we need to deal with. So, for example, there's been no process in front of the Sentencing Commission. There's been no Blue Ribbon Legislative Panel. There's been no Governor's Study Panel. There's been no panel of the Supreme Court. And I would encourage you to do that before you do a reform of this size. Next point is I would say that the package relies heavily on the use of criminal risk assessment algorithms, which are problematic. 100 civil rights groups in New York State issued a letter to the administration in November of 2017 when they said, quote, "We, the undersigned organizations, are united in the belief that we do not have to add dangerousness to New York's bail statute to reduce our pretrial detention population. The use of risk assessment instruments to predict dangerousness will further exacerbate racial bias in our criminal justice system, and the use of these instruments will likely lead to increases in pretrial detention across the state." December 8th, the Robert F. Kennedy Foundation and 137 other civil rights groups similarly sent a letter, and they said, quote, "We cannot abide legislation that maintains other for-profit influences or replaces money bail with mass community surveillance, racially biased risk assessment instruments, or the expansion of preventative detention," which candidly is on the table here. Also, 110 national civil rights groups, including the Leadership Conference on Civil Rights, have said don't use pretrial risk assessment algorithms because, quote, "these tools can worsen racial disparities and allow for further incarceration." And at a broader 38,000-foot level, I think the use of these algorithms has led to generational mass incarceration. Agreeing with me is Professor Robert Worth from Rice University, who said, quote, "I would contend that risk assessment has, to this point, helped organize the penal state and fortify its legitimacy, and the rise of the historically unprecedented legal penal complex has occurred alongside and in interaction with the proliferation of risk knowledge discourses and technologies. No trial can ever exonerate someone who has been labeled as dangerous under these tools." And so I think that's a major problem here. Next point is I think speedy trial reform would be a better answer. That was argued when the Federal Bail Reform Act was passed. It's the most bipartisan, cleanest, best way to get it done, which is just shorten the process. It's better for everybody. One state attorney general recommended, and maybe worth considering, is maybe there's a faster trial track for the in custodies. And I would advocate for that. If you can't afford the whole banana, at least give the people in custody a speedier process. Final point, when I read this package, I was stunned. I was stunned that anybody would come in to this state capitol building and advocate for the expansion of preventative detention, which has largely not been allowed in New York, which the state of New York has rejected since 1984 when the federal government went in this direction. And I was just stunned to see it in there. I don't think it's a good idea. The article that I present, and certainly the data backs it up, the federal government has tripled pretrial incarceration since they went to a system of preventative detention. Maryland tried it. Jail population went up 20% in Baltimore City in the first year. And in New Jersey, a majority of all cases are getting a motion to detain, which is the story that you're going to hear from my colleague sitting next to me. There's also been very little benefit shown in terms of preventative detention as a crime control measure. And finally, I would just end with a quote from Thurgood Marshall. While perhaps Justice Rehnquist and a majority of the Supreme Court gave this legislature and this government the power to preventively detain people, that doesn't mean it's a good policy idea. Quote, throughout the world today, there are men, women, children interned indefinitely, awaiting trials which may never come, or which may be a mockery of the word because their governments believe them to be dangerous. Our Constitution, whose construction began 2 centuries ago, can shelter us forever from the evils of such unchecked power. Over 200 years, it has slowly, through our efforts, grown more durable, more expansive, and more just. But it cannot protect us if we lack the courage and the self-restraint to protect ourselves. Today, a majority of the court applies itself to an ominous exercise in demolition. Theirs is truly a decision which will go forth without authority and come back without respect. And that is exactly what happened, is that pretrial detention tripled. And I would encourage you to not go into this ominous exercise in demolition.
Good evening. My name is Edward Fortune, and I wanted to present my issue with this bail reform. As a New Jersey resident, I became a victim of the New Jersey Bail Reform Act, and I definitely want to give that perspective and why I'm opposed to your eradication of the Eighth Amendment, basically, the right to bail. For 230 years, this country's had bail. It's always been a right. It's been treated as a right. And, you know, a couple years ago, I was working as a columnist for a newspaper, the Trentonian, in Trenton, New Jersey. And as a columnist, I picked on politicians. I called them names. I said little things that I probably couldn't get away with at a dinner table with my mom, you know. But, you know, and I called, you know, I antagonized people. But totally free speech. And then I got into a dispute basically with the local police department and the prosecutor's office, and I ended up getting hit with like 40-something tickets, indictments, charges, whatever. And basically it was all fake. It was all phony. It was because I had, you know, used my mouth. I've been a nonviolent person my entire life. I've had no violent charges. Yes, I've been arrested for marijuana a few times. I'm a public advocate for the legalization of marijuana, but I even present myself as a peaceful, proud, patriotic pothead. And when when the Bail Reform Act was being discussed by Governor Christie, just reading it and realizing that a judge, at the end of the day, it was up to a judge, I knew that I would become a victim of the bail reform. Well, I mean, I joked about it and said that I was a Weedsterdamus because one day I'm going to be a victim. And sure enough, within 3 months of the enactment of the Bail Reform Act, I was singled out with phony charges and charged. And this is what I think, that these type of arguments are never presented. When I read about people talking about the Bail Reform Act, it's always talked about in this way that's going to help minorities and this, that, and the other. I was in a jail, and everyone detained were minorities, to be honest with you. But the Bail Reform Act can be used as a tool, as a weapon by prosecutors or malicious police officers. In the case of police officers, they've learned really quick what to write on their tickets and their reports. You know, they label you as a danger to the community. That's what I was labeled as, danger to the community. I was labeled as somebody who would obstruct justice. You know, like that's the Minority Report right there, future crime. But these are the arguments that were presented for my detention. Nothing about violence. Nothing about, you know, any violent crime I did or accused of doing. I was accused of witness tampering because I called somebody a rat on Facebook. Repeatedly, but I called them a rat. And they were a rat, you know, and I don't think that was what bail reform was supposed to be about, because vendettas, political imprisonments can happen because you lost the right to bail. The right to bail was put in place by the founding fathers of this country because they had already went through it with the with the king. You know, they totally understood that if you can just lock somebody up, throw them in a dungeon, you know, you can force plea bargains, you can get punishment without a conviction. You know, and we know that Ben Franklin and several of the founding fathers all used the same quote, that they would rather 100 guilty men be freed than one innocent person to be jailed. And trust me, I did 447 days detained, and the very first day I walked in there, I was an innocent man. And I wasn't the only one. I happened to have a little fame, and my entire case was covered. But the fact of the matter, right now in New Jersey, there are hundreds of people, hundreds of innocent people in jail, and they're all in jail victims of the Bail Reform Act. And you people are about ready to vote on the same thing here in the state of New Jersey, I mean, the state of New York. You have in your power right now to not to let what just happened to me happen in the state of New York. And this, I don't really think is really, like, I'm not a real oddball in this system. There's like 4,000 people in the state of New Jersey who were detained, and I'd say probably half of them were not violent people. Thank you.
Thank you. Actually, this question is for Ms. Eskenazi. Hello, ma'am. It's been a while since we've seen each other. I figured that the positions on this document from the New York State Bail Bondsman Association is obviously expresses your positions as well.
That's
correct?
correct.
There's one I just wanted to ask because I remember vividly the conversation that we had in my office, which again I thank you for coming to my office, and when we talked about the bill that I passed back in 2011 on charitable bail. And I remember very specifically that the harsh criticism that you gave to the piece of legislation, you folks have obviously changed your mind, which I'm very thankful for, since I'm a big believer in charitable bail. I also believe that we should get rid of bail totally, but that's a different question. I just wanted to figure out what, I'm thankful that you changed your opinion, and I want to see why that was the case.
Are you asking a question, Senator?
Yes, ma'am, I am.
Please
Why
go
did you
ahead.
change? Why did you change? How did you change your position? How did you come to change your
In terms of what
position?
specific subject, sir?
On charitable bail, back in 2011, I passed a bill to create charitable
Can you
bail.
read whatever it is that you're referring to me so that I can be educated as to what you're speaking of?
Yes, ma'am. Facts about bail reform, the document that you just handed to us, there has claims and facts. Claim number 6, charitable bail is the enemy of the bail bond industry. Fact, the bail bond industry is 100% in support of charitable bail. These organizations provide an essential and effective means of ensuring that truly indigent people are afforded the same opportunity to be free as those who are more fortunate, free as those who are more fortunate. I could not agree more. I just wanted to know the position, which is the one that you have now, which I'm very thankful for. How did you reach this conclusion? That was my
Senator,
question.
if it's all right, may I answer on behalf of the organization?
I'm going to answer. Then you can answer.
Certainly, anyone can
I'll
answer.
cede to my associate.
Okay, so the fact of the matter is, under Section 6805 of the insurance law.
Please use the microphone.
Under Section 6805 of the insurance law, charitable bail is supposed to operate within the realm of indigency. It doesn't happen as we speak, and I said that to you when we met in the Bronx, and I'll say that to you again. I don't think that indigent people should be incarcerated. I never have in 25 years. I've never thought that. I've helped tons and tons of people over the past 25 years. But the fact of the matter is, when you walk into the office to get food stamps or a charitable piece of anything in the state of New York, you have to have some sort of proof of indigency, Senator. So the fact of the matter is, I don't disagree with you that charitable bail does have a role in the bail system. I just think that it should operate within the realm of Section 6805. That's my answer.
All right. It's different than what I just read, but
Senator, if I may, just,
well, my time is up actually. So
Sorry.
but thank you for your time. I yield back, Madam.
Senator Diane Savino.
Thank you, Senator Kruger. So I want to ask Mr. Forcione, so so Governor Christie signed the Bail Reform Act, and that eliminated cash bail across the state. And I remember at the time there was also some concern about the state did not give funding to the localities who were supposed to deal with either pretrial tracking or detention. But what I'm really disturbed about, so if what I'm hearing from you is correct, because cash bail wasn't an option, and you were obviously the victim of it sounds like a political vendetta. You were detained, pre-trial detention for 447 days.
For 447 days. Then I represented myself. It was a ridiculous charge. It was a phony charge. Everyone knew it was a phony charge. And I represented myself. And the jurors practically laughed me and did not guilty. But I spent 447 days. I appealed it twice. I appealed the detention to the state appellate court. But the way the law was written, the judge had every right to do what he did.
And there was no...
But the ironic thing was I was a columnist for a newspaper, and I wrote about that 2 years before it happened to me, that the fact that a judge can make this arbitrary decision, that, like, who cares if you have bail? Now you can have political imprisonments. It didn't happen to me. And it happens, like, in other ways, too. Just a guy on the street gets into a beef with a police officer. Now, when he writes his ticket, he writes it in a way, or whatever, whatever his charge is, maybe it happens a couple weeks later, but he writes it in a way that the prosecutor now gets. It's like dog whistling. Oh, this guy, they want him. And she presents that argument, or they present that argument to the judge, and the judge rubber stamps it with a detention. And now when you're detained now, the way the law is written, your time doesn't even start until you're indicted, which can take 90 days. So it's like those 90 days didn't count. And then they have 270 days to prosecute you. So there you go. You're right at a year now, and you've been charged with a crime. If you're an innocent person that year. Now, I will say this also. I went to prison before. I went to prison for 18 months for a marijuana charge, and I did it. I had it, whatever. And I did those whole 18 months, no problem. This charge, I was an innocent man. I was in there with other innocent people, and it was all because of the Bail Reform Act. I pulled hair out. I was so mad and angry. I'm still feeling it. I'm mad about it. Like, that's not the America I grew up in. And I tell you what, like, I did my time. A lot of people don't even know it. I did my time in the Marine Corps, the Army, and the United States Army. You know, I always thought that I had a right. The Constitution applied to me. I know the first 10 constitutional rights off the top of my head. And the Eighth Amendment has been eradicated by bail reform. And this isn't the argument that say the bail reform people are going to say. I mean, they're going to say it, but from the point of the defendant, it can happen to you or your kid. You can get charged with something, and then the judge says, "Hey, I'm going to detain you." And now you're working off of these numbers that the legislature comes up with for your speedy trial, which isn't really that speedy if you're locked up. It's at least a year away. And in my case, 447 days, a couple days short of 16 months.
Thank you.
Thank you. Thank you. To the gentleman in the middle, I'm very sorry to hear your story. I haven't practiced criminal law, but I appreciate the fact that we have those rights. Probably some of those politicians you spoke of probably deserved it as well, knowing New Jersey. But maybe this is for the other members of the panel. Are you saying that if, and I haven't gotten up to speed on this, and I know it's coming down the pike with this cash bail, are you saying the elimination of cash bail will adversely affect defendants' rights to get out pre-trial?
Yes, because this proposal relies on the very preventative detention that held this gentleman in jail. That's the solution, is that we will decide who is dangerous, and under this proposal, one of the proposals, a mere preponderance of the evidence of a risk of flight will be sufficient, which is a low bar, and I've never seen any state go that low.
But wouldn't a defendant have a right to post a bond? Not on this proposal.
No,
in
not
New
in New
Jersey,
Jersey.
they eliminated. They basically
44 bonds were posted last year.
Okay.
In this particular instance, the new proposal calls for no posting of bonds under any circumstance. It's either release, program, or remand.
Yeah, and I promised to get up to speed on this, but I guess I actually thought we'd have people saying, "What are you nuts? We want to have cash bail so defendants aren't getting out that may be dangerous, et cetera." But this is interesting. And as far as speedy trial goes, don't we have plenty of rules on the books about speedy trials? Isn't that kind of you got to have not that you got to have a good lawyer, but
yes, but in New Jersey it was 270 days.
Okay.
Now I was indicted prior to my arrest. So that 90 days for me was already taken up. The day I was arrested, my days started. There are other people, I've been out now 7 months, there are other people who got arrested after me that they are cruising in on 2 years now. because they were denied bail. And I could have made bail. I absolutely could have made bail. But I was denied bail. And I sat there for 16 months for a ridiculous case, and it wasn't a vendetta.
One of the proposals in the pending legislation is calls for desk appearance tickets in some instances, provided you can produce ID. One of the problems with that is it circumvents the speedy trial rule, because speedy trial doesn't start until the person is actually arraigned. And in this instance, they're claiming it's going to be a 20-day period between arrest and your appearance on a desk appearance ticket. I'm a criminal defense attorney for 30 years. The time between a DAT and appearance in court is about 2.5 months. So all of that time now is no longer going to be charged as speedy trial time. So it's going to have an adverse effect on speedy trial if some of these provisions are put through.
Okay, thank you.
Can I say one thing on
It's
that?
up to the chair. You got 20 seconds, so go
Or
ahead.
20, okay, out of that 447 days, 134 of those days also didn't count because I filed a motion. And when you file motions, according to the New Jersey bail reform law, the judge has up to 60 days to decide, and those 60 days are excludable time is what they call it. But when you're in jail, and they say it's excludable time, and you wait 60 days, like it didn't count. It did count every 134 of those days, I remember.
Thank you. Assembly?
Assemblyman Lenthal.
Thank you. I just wanted to say that I guess you've seen the bill that was proposed by the Assembly, first of all. That's different from the budget bill that the governor has proposed. And the bill of last year is a lot different. And I just wanted to tell you that it wasn't 1984 that preventative detention was rejected. It was rejected as early as 1965 when we had, I wasn't here yet, when we had a Republican legislature at the time, and we had a Republican governor, and we had a commission to overhaul the penal law. And the subject of bail was one of the most difficult subjects, and still today is the hardest part of criminal justice reform as far as I'm concerned. But in those days, they considered for hours and hours the question of preventative detention, and it was rejected. And it wasn't by a progressive governor, a progressive mayor, or a progressive legislature. It was rejected by a Republican legislature and a Republican governor because it doesn't work. And we understand that in our bill. And we still provide for cash bail for violent felons without preventative detention. And I think that's the way this system should work. If we provide no bail for people who are misdemeanants and for people who are nonviolent felons, I don't know if you agree with that, but that's a system I think I could work with and support philosophically. And I don't know how you feel about it, but I think you could be part of the solution if you could help us with proposing a bail reform system that actually works.
Just briefly, I would agree with you, and I appreciate the history on that. I need to go do some more research on New York specifically. I agree preventative detention is not an answer. Can we be a part of the solution? I think so. On our website, there's a thing called the Fourth Generation of Bail Reform. Give it a read, and certainly we'll do everything we can to be whatever part of the system that New Yorkers want us to be a part of.
Assemblyman Lenthal, I just want to thank you for your comments. You know that I've been coming to see you about this issue long before it got popular with many of the younger generation here since 2013, sir. So I do think that we have a lot to offer in terms of expertise, and we look forward to working with the Assembly and the Senate in that specific regard.
Thank you.
Thank you. Senator Zelnor Myrie.
Thank you, Madam Chair. Let me just say, I think reasonable minds can disagree on the substance of how we reform bail. I think having a debate and a discussion is healthy. What I think is not allowable is conjecture, misinformation, and mockery of what is a very serious issue. And I think some of what we've seen today is a disgrace to people who have been criminalized because they are poor. People have died because they could not afford bail. This is not an issue to play games with. This is not something that we should take lightly. And I think some of the conversation and the discussion today has been highly unacceptable. It is not based in fact, and I think we have a duty and a responsibility to speak up when we see that. There are a number of things that have been mentioned about this bill that I think we don't have enough time to correct, but I wanted to go on the record to say that some of the things put forward are just simply not factual. And, the citing of New Jersey, I think, is fine, but it is my understanding that we are in the New York State legislature, and that it is our responsibility to legislate for the people of this state. So I want to underscore, and this is a comment and not a question, that we're going to take this very seriously. And again, we can disagree on the substance. But what I've seen today is unacceptable, and this mockery of the process and this taking it lightly, I cannot stand idly by and listen to it. So I look forward to working with my colleagues in the Assembly as well as my colleagues in the Senate. But this is an issue that is too serious to have what we've seen today occur. Thank you, Madam Chair.
Thank you. Any others? No, we're finished. Oh, Assembly.
No, we're done.
Oh, you're done? Yes. Okay, then we're done. Thank you very much for your time.